Well, welcome back to another Cordell and Cordell Town Hall. I'm Scott Trout, CEO and Managing Partner of Cordell and Cordell. And today we're going to talk about those dirty tricks in divorce, things that many guys experience but aren't spoken about. And so today we'll be joined by four panelists from Cordell and Cordell around the country. But make sure to stick around for the second half of the town hall, where you can submit your questions and get answers live today. So some of you have already done that. You can submit that via the Q&A section or the chat box. Make sure to do that right now. We'll get you in line to get your questions answered by our panelists today. If you don't have time to submit a question, you can do so via email, either during the show or after, at coronavirus.divorce@cordelllaw.com. We'll either cover those during the weekly podcast that I have that you can find on our YouTube page, or we'll address them in the next town hall that we do in October. Again, coronavirus.divorce@cordelllaw.com. And when submitting your questions to be answered today, just give us a first name and give us a state. If we can throw it to one of the attorneys from around the country that are licensed in your state, we'll do that. Otherwise, just go ahead and list it and we'll try to answer to the best that we can. Which brings up an important point, that this should not be taken as an attorney-client relationship or legal advice. I start each of my podcasts that way, as well as the virtual town halls like today. Just make sure each of your cases are unique. We want to gather all the facts. We just don't have that opportunity to do so today. So what we talk about really is our experiences. I'm only licensed in Missouri, Illinois, and Georgia, and our guests, as they'll introduce themselves, have limited licensure as well. We have viewers from around the country, including the world, since we're licensed in the UK. And so just keep that in mind. These are to be virtual kind of talking points. We want to take those to an attorney. And I always talk about finding a lawyer who practices exclusively in domestic relations. That's one of the first and most important things you want to consider when finding an attorney that deals with family law. Today, as always, we'll bring you information for issues related to family law before, during, and after divorce. If you want to schedule a consult, which I encourage you to do with us or find an attorney, but particularly from around the country, you can reach us at 866-DADS-LAW. Or you can find us on the web at cordellcordell.com, across social media. And this, as well as all of our previous, in the 26 weeks we've been doing this during the coronavirus, you can find our virtual town halls and all of our podcasts on our YouTube page. You can also check out Men's Divorce or dadsdivorce.com for more information and articles on topics in family law written by attorneys from around the country. So, again, submit your questions to the Q&A section and the chat box. Otherwise, send us an email, coronavirus.divorce@cordelllaw.com. So let's get right to our panel of attorneys today from Cordell and Cordell that are going to talk about those dirty tricks that your spouse is going to employ, or we've seen in our experience. Let's start in Houston, Texas, and welcome Misty Dennis back to the town hall.
Thank you, Scott. Thanks for having me. As Scott mentioned, I'm down in Houston, Texas. I am the lead litigator in the Houston office. I am board certified in family law by the Texas Board of Legal Specialization. I've been practicing almost 22 years, so trust me, I have seen plenty of dirty tricks in my practice.
That is no doubt. It's we always talk about, I tell clients I think I've seen it all. And then all of a sudden, something else comes in. But it's always good to talk about these things, and guys know what to expect, and to kind of talk of the examples. And I think you're right, Misty. You've got plenty of experience, and we'll talk about some of those things that you've seen. Let's go out to California. Welcome back, Jason Hopper, to the town hall.
Hey, Scott. I'm glad to be back here again. I'm a lead litigator with the Northern California offices of Cordell and Cordell. Practice primarily out of Sacramento, but have a statewide practice with the firm. I'm licensed in California, as well as the state of Indiana, and I'm a member of the United States Supreme Court Bar. And I've been in practice for close to 15 years and with the firm for over 10 years.
Thanks, Jason. Welcome back, Asa, up in Albany, New York. Welcome to the town hall.
Hi, thanks, Scott. I'm Asa Neff. I practice primarily out of the Albany, New York office. We also have offices in Saratoga and Buffalo, but I practice throughout the New York area. I've been practicing law for 15 years, exclusively in the area of domestic law for the past 9 years with Cordell and Cordell. It's a pleasure to be back. Thanks for having me, Scott.
Thanks, Asa. And let's round out the panel for today that we're talking about those dirty tricks exposed. Once again, joining us in our town hall is Melinda Kaufman up in Dublin, Ohio.
Thanks, Scott. Thanks for having me back as well. So I'm happy to be here with everyone this afternoon. I've been practicing for 10 years. I'm licensed in Ohio as well as the state of Florida. My primary practice is in Ohio, though, and we do have 6 offices throughout the state. So whatever county you're in here, we'll have you covered.
Thanks, Melinda. And as you mentioned, we've got offices around the country, including the UK. I know guys watching now have questions, and certainly we're available to talk virtually, or we can do a consult by phone, or in person where appropriate. So check us out online at CordellCordell.com, or give us a call at 866-DADS-LAW. Happy to answer your questions after you take some notes today to kind of fill in the gaps. That obviously will exist after you have questions and take some of these notes. So we'll begin our town hall shortly after this commercial break.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell Cordell. This is what we do.
Welcome back. So before we get started, obviously, again, we're available for consults. Give us a call at 866-DADS-LAW. Don't forget, we want to get to your questions and provide as many answers as we can. Submit those via the chat box or the Q&A section on your screen right now. Otherwise, you can email them to coronavirus.divorce@cordelllaw.com. Jason, I'm going to go out to you in California. And one of the things that often guys come in and talk about is, out of the blue, for the first time ever in their marriage, in their relationship, when they have kids, out comes allegations of child abuse, neglect, drug, alcohol use, domestic violence allegations out of nowhere. You know, is it prevalent in your experience and kind of out there in California that you see that this happens a lot involving custody issues?
You know, Scott, it's really not uncommon at all. As to the initial consults that I meet with as far as prospective clients, I would estimate at least half to 2/3 of prospective clients have some aspect of either a domestic violence claim, a substance abuse or alcohol misuse type of claim. And of those prospective clients, I would say at any given time, anywhere from 25 to 50% of my active cases, and I would say, I would probably speak for other members of the firm as well, have some likelihood of those types of claims being involved in their cases. You know, certainly, I represent a fair share of guys who are victims of domestic violence, but in practice, you know, men are overwhelmingly accused of DV much more than women. You know, generally, a lot of the studies show that it's a 8-to-9 or a 8-to-1 or 9-to-1 ratio of men being accused of being a perpetrator of domestic violence. So it's common. It's something that we see a lot of. It's a very stigmatizing type of accusation that, even if it's baseless, even if it's ultimately dismissed, you know, the fact that it's raised can really kind of color the judge's opinion of a case and moving forward. And it's something that we really want to be proactive with and defending against when we have those types of claims being raised.
So, you know, you think about it, and it does. It tends to cloud perhaps an opinion by the court, by the bench. But what is there? I mean, why do they do it? What's there to gain? I mean, I often talk about, I think, no matter what state you're in, whatever county, allegations of abuse or domestic violence are probably the most over-abused statute, because it really does cloud those issues that really do need it, right? But what is there to gain if your spouse is going to make those allegations against you?
Well, so if a litigant's willing to take, you know, a little liberty with the truth, or maybe exaggerate, 15 seconds of something that happened in their life, there's a lot that can be. It's a very effective means to an end if you are a little unsavory and willing to kind of stretch the truth. So let's say we have some divorcing spouses. Something that I see a lot of is, you know, one party's mad at the other and they want them to move out of the residence, and they really don't have a legal basis to kick their husband out of the residence. In California specifically, there has to be a claim of domestic violence. The court can't just evict a person with no basis. And so, you know, if the unsavory litigant can either wait for a motion to be heard, They may not want to wait that long. It might take 4, 5, 6 months. They may try to negotiate the party being removed from the residence, and that might be expensive. Or they could just take matters in their own hands, make a claim of incident of domestic violence or abuse, and you rub together the magic words, and you might get an order within 24 hours to achieve your objective. There's also a big financial incentive that I see a lot of clients defending against. Whenever I have a client that, let's say that their wife is the breadwinner in the family, and that spouse has some exposure for spousal support, which can run in the thousands of dollars per month range, or for payment of their attorney's fees. The first thing that I want to proactively address with the client who has this expectancy is, what's your wife going to say, and what sort of story or narrative are they going to compose to try to cut off their exposure to paying your attorney's fees, or to cut off their exposure to paying your spousal support. So there's a big financial incentive as well. And then when we throw kids in the mix, there's a lot of weaponizing that can come with these types of claims to really try to get an upper hand in litigation. So there's a lot of proactive efforts that we want to take in defending. We don't want to always be on the defensive. We want to kind of come out swinging when we have these types of claims to aggressively defend on behalf of the clients.
Yeah. I mean, it is actually, you think about it, I think it's one of the more powerful tools for your spouse to use against you, because the ramifications are huge, which leads us into the question about what can you do. Most guys get served with this order of protection, this domestic violence order, and they think, well, that's it, I'm going to lose. What can, for example, Cordell and Cordell attorneys do? And then should they go alone? I know that's a two-part question, but many guys think, I'm just going to go in there and tell my side of the story, it'll all work out. Should they do it?
Yeah, so I mean, really, it's one of those situations where you can't afford not to hire an attorney. The analogy that I make in a lot of prospective client meetings is, if you have a dental need, you're not going to take a pair of pliers and yank your tooth out. If you have a legal need, this is where an attorney can really, really assist you. And because the outcomes of having a DV finding against you are so dramatic and can really affect your case in so many ways, they can affect, number one, your relationship and your time with your children. Number two, they can, with a DV finding, can significantly increase your support obligation, or can significantly cut off an otherwise viable claim for support of your own. It's really one of those things where almost across the board, bringing in an attorney pays for itself, because you can mitigate your exposure and your cost. So my approach from the attorney side is, I have to anticipate that, unlike a divorce case that doesn't have a DV allegation, I would know that generally 2/3 or more of those types of cases are going to resolve without going to trial. But with a DV component, I would say 89% of the time that case is going to be tried, or at least the DV component of it's going to be tried. And so I really want to approach the case as a litigator first and foremost, to really put together a very cogent defense. Certainly, vetting out what the claims are is a very important of the process. There's a misconception, I think, that's out there that what the courts consider to be abusive behavior, that has to involve some sort of physical violence. And for a lot of litigants, that's not the case. It can include mean words. If you have in California disturbed the peace of your spouse, that in and of itself can be a basis for up to a 5-year order of protection. And so what we want to do when we get a client is, we're often going to utilize some discovery tools. I would say the use of a deposition when it's a he said, she said type of situation, to where credibility is really going to determine the outcome of the case. That's an imperative, and that's something that I would recommend and utilize in almost every case where there's a DV component to it.
Yeah.
So if we think the other party's either lying or exaggerating, well, that needs to be parsed out, and that needs to be subject to cross-examination, and it needs to occur before you get in front of the judge.
I'm going to say real quickly, there's so many parts of the petition for the DV, for the domestic violence order, that you can attack from a substantive, not substantive, but procedural. I think guys need to make sure they immediately go seek a lawyer, as you're suggesting. I know there's a temptation, because it's expensive, to go at a loan, but when you just threw out a 5-year order, I mean, that's just craziness to lose and get a 5-year order against you that has all these provisions that we'll talk about in a minute, that could affect custody, could affect possession of the home, expenses, you name it. It's really to me, it's one of the things that I expect. I tell clients, look, I expect all of a sudden these allegations to arise. It is a dirty trick. Opposing counsel may start leading their client to water by saying, now, did they scare you? Did they threaten you? Did they do anything that would cause you concern about your health and safety and well-being? Now you've got the client thinking, well, maybe. And now they know kind of what the allegations they should be making to try to gain an advantage. But what we didn't talk about is, even allegations aside from domestic violence, and to wrap kind of this subject up, is alcohol and drug abuse allegations. I mean, that's prevalent too, don't you see that?
Well, absolutely. And it tends to creep its way into most contested child custody matters. And so, what my approach is going to be, number one, is I want to investigate with my client and maybe play a little bit of a devil's advocate with them to see if there is any validity to the claim. Have there been prior arrests? Has the prospective client, had some trouble keeping a job or maintaining a job? If my client is telling me, look, there has been some alcohol or drug use in the past, well, then we want to get in front of it. And there are some strategies that we can employ to really take the wind out of the sails of the opposing party. One thing that I utilize when there's an alcohol-based claim is there's this program called SoberLink. And yeah, there's a cost associated with it. It's a pretty nominal cost, about $100 a month. But, if I get a client that is accused of being, out of control with their drinking, but yet they're willing to sign up for SoberLink, and all they have to do is blow into a stick at the outset or at the end of their visitation. I mean, that really destroys the credibility of the other side, as long as my client's abstaining.
Right.
To ensure that there's really no safety concerns whatsoever.
Yeah.
For things like substance abuse or substance misuse, again, we got to get to the core of the issue and to the core of if there is any merit to the claim or if there isn't. If there isn't, it's a matter of proof for the other side, and it's easy to make a statement, but it's hard to prove it in court. If there is a history or a background, then maybe it's something where we pivot more towards how do we make you look good in court? How do we present to the judge to take away some of these concerns? And that might be taking some proactive efforts as far as proactively, without a court order, seeking substance abuse therapy, attendance in AA or NA meetings. Certainly if the response from my client is, this is all out of the blue, there's no merit to it, well, then I'm going to try to look at bank records, try to show, look, you say my client goes out to the bar 6 nights a week. Well, here's my bank statement that shows there was one bar visit in the past month. Things of that nature, that to where you can really employ a lot of the tools that are available to your attorney to help proactively defend against these types of claims.
Yeah, you raise a good point, and it kind of leads me to Misty, to go to you, because we talk about these domestic violence orders. They're called something different in every state. It could be adult abuse, protective orders, orders of protection, DVs. Misty, I guess what I see, and I want to hear your perspective, is kind of the dirty trick is, you have a spouse who goes and finds an attorney that begins to think, okay, here's the goal. Limit the ability of him to see the kids. Limit his contact. Limit his visitation. How do we do it? Oh, domestic violence. Is that what you're seeing, that you can use that effectively to limit visitation, contact, and custody?
Unfortunately, it is. Here in Harris County, we have a dedicated court specifically for family violence, for protective orders. So one of the tricks that a lot of attorneys are using now is to file a protective order along with their petition for divorce. Well, what happens is these protective orders get clogged up in the system. I recently had a case where a protective order was filed in October of last year, but was not heard until August of this year. So my client essentially went 10 months without being able to see his child. What happens is, when you file these protective orders, the court will set what's called an ex parte protective order, which will eliminate any access with the child. And these ex parte orders are granted without any hearings and without any notice to the other party. So if somebody, again, is willing to go in and exaggerate a circumstance, the court will grant this ex parte order, which will effectively eliminate any contact with the child.
Yeah.
And it's a very unfortunate situation that's happening here in Houston and Harris County, and I'm sure that it's happening everywhere, but this is one of those tricks that parents are using to eliminate and prevent access. What happens then is if the court is willing to issue a protective order, it then would prevent the parent who's being accused of the abuse from having joint rights with regards to that child, or even having regular visitation should visitation be granted. When there's a protective order in place, or there's founded family violence, then the court would issue only supervised visitation to the child. And here in the Houston and Harris County area, supervised visitation is sometimes twice a month for 2 hours during a visit. So these are tools that people are using essentially here to try to eliminate and reduce the contact and visitation with the child, when a lot of times there was no family violence. Just like in California, here in Texas, if there is a threat of violence, if you say, you know what, I'm going to kill you, the court can take that as family violence and issue a protective order. So people have to be very careful, very, very careful in these type of situations. When you feel like you're getting to that point, walk away, because they definitely come back and use these against you.
It's one of the 10 stupidest mistakes we've talked about. We've got a book on it. It is avoid confrontation at all costs. Because again, now guys here watching and listening are seeing exactly how this can be abused. It is a dirty trick. It's exposing it for what it is. And I think, the ramifications are just too big, because we know, and I've talked about this in the evening seminars, we do live, judges, they don't like to take risks. And when you've got a status quo, like you just described, a gentleman who has an order in October, hasn't seen his kids till August, judges don't want to deviate. If the kids are doing well over those 11, 10, 9 months, what do you think they're going to do? They're going to take the easy road and just say, well, the amount of time he has under this order seems to be sufficient. So we got to be careful. It's really dangerous to get into a status quo when you have some of these, which raises the question about, now let's talk about COVID. I call it convenient. I see litigants taking this as a convenient excuse to say, oh, COVID exposure, sorry, you can't see the kids. Are you seeing that, Misty?
We are seeing a lot of that. I will say that here in Texas, again, the Texas Supreme Court issued an order which directed parents who are under visitation schedules to follow the visitation schedule regardless of any stay-at-home orders or any precautions that the states are putting in place for visitation. But often what I have seen, and what I'm still seeing sometimes, is a parent will say, hey, I think I've been exposed to COVID, and so now the kid has been exposed to COVID, so you're not going to get any visitation this week or for the next couple of weeks because I need to keep my kid in place because I don't want to expose you. Or what's happening is they're saying, I'm afraid you may have been exposed to COVID either because you're working outside of the home, or, hey, I saw on Facebook you were at a sports bar, so now you're going to expose the kid to COVID. So I'm going to prevent you from having any access to the child in order to really limit access unjustifiably. In those situations, it's best to contact your attorney, because again, we have this state mandated order that says you cannot deny access because of the COVID regulations or because of your fears of COVID. That's still a violation of your court order, which is subject to an enforcement. So it's important that if that's coming up, if people are making these types of excuses as an attempt to try to eliminate or prevent access, that you contact an attorney so that you can enforce your rights, because you just can't do it.
With this COVID, it kind of rolls into the next thing, which is you see mom using that and saying, the child's afraid to go now. It's, I've done everything I can. I tried to get them to go, but they just don't want to have custody or visitation today. So we're not going to do it. I'm not going to do anything that would, injure their psychological status. Are you seeing that as well?
Unfortunately, we are. And it seems like there's two groups of children where this is happening. This is happening with children who are a little older, 12 to 16 to 17, and then the very young children. What's happening with the older children, I believe, and I think that statistically what's happening is it's a matter of alienation. One parent is telling the child, oh, your mom or your dad is doing this, your mom and your dad or your dad said this, your mom or your dad is mean, these things that they're saying are abusive, maybe you shouldn't go. And what's happening is they're making the children afraid to go. So when the child shows or exhibits any sense of fear or resistance to going, the parent will use that as an excuse. Hey, I can't send my kid over there because she's scared to go. I'm protecting my child. It's my duty to protect my child so you don't get any visitation.
Mm-hmm.
Unfortunately, we are getting a lot of that. And what we end up having to do in these situations is, get the court to appoint a therapist or a psychologist, or get the court to appoint some kind of amicus attorney. Here in Texas, we refer to them as amicus attorneys. In other places, they're referred to as ad litem's, but someone to get involved and investigate it. The problem is that you'll end up spending a lot of money under, having to do this, having to fight these allegations, and you'll end up wasting a lot of time and missing a lot of visits in between. So this is another really dirty trick. And I think that one of the best things that people can do to protect themselves is when they get a sense that this is coming up, hey, they don't want to go, hey, they're acting afraid. One of the things I tell my clients is record the exchanges. If you can, put a camera up in your car, record the exchanges, have somebody else who's present during the exchanges. Because a lot of times with these children, it's a he say, she say thing, and the courts don't like children to testify. So you can't get your 12-year-old to come into court and stand up on the stand and swear that this particular thing happened, which is often why they are appointing, therapists and amicus attorneys and other things to really investigate it. So be careful when you get a sense that this is a claim or an allegation that somebody is making. Protect yourself, because a lot of times it's not true. A lot of times it's a matter of parental alienation and parents making up things that just really are not true in an attempt to try to use the child as an excuse use the child as an excuse to not have to participate in the visits.
And you raised, a really good point, Misty, about parental alienation. It's one of the things we talk about in these seminars that we used to do live, last year. We'd say, and I'd always ask the question, show of hands, who's heard of parental alienation syndrome, PAS? Maybe one hand would go up. So you're watching right now or you're listening, go Google that. It's something that can be effectively used. I think I see it happen in 90+% of my cases in custody matters where maybe a mild form to an extreme form. But I can tell you as it goes towards the extreme, it is amazingly damaging to your relationship with your child. And you just described it about, the child doesn't want to go. And then mom will go to the child and say, well, your dad never showed up for visits, when the dad did. He called and you just said no. So I think, right now, watching Google PAS, parental alienation syndrome, it's something you want to talk about with your attorney, whether or not it applies to you, whether that's not something you can use in your case to try to further your custody battle. So let's move on to ASA real quickly. ASA, another dirty trick we talk about is underemployment, maybe hiding your income, cash jobs. I want to talk a little bit about that. That's something you see on social media a lot where someone's has a side job. But I guess to start somewhere, are you seeing where the spouse perhaps stops working just shortly before the divorce or maybe a year or two before the divorce and then says, I don't want to go back to work? Are you seeing that?
Yeah, we do see that, unfortunately, more often than we should. And for a variety of circumstances, you'll have a spouse say that they want to leave the workforce, either to spend more time with the kids or to work on themselves. And then they have little or no income to show. I have a case that I worked on just recently where my client's wife was a nurse practitioner, but after 10 years in her field, she said she wanted to stop working. My client made a lot of money and thought maybe this would help their marriage, so agreed to it. A year down the road, and she's been carrying on an affair with her yoga instructor, and she files for divorce.
Yeah.
Then is going to the court saying, I have no way of supporting myself. I need spousal maintenance, and it's got to be based on my having no income. And it's a difficult position. All I would say is that, attorneys have a lot of things that we can do to make sure the courts aren't going to use zero as anybody's income.
Right.
In that particular case, she was a licensed nurse. We were able to hire a vocational expert to testify as to her earning capacity. Looking at somebody's W-2s, their taxes, their pay stubs is only one tool of showing how much they earn or how much they can earn. And that's really the standard in New York, and I know a lot of other states, not just how much you're actually earning, but how much you're capable of earning. So in that case, we were able to avoid any real support obligation by showing that she's capable of earning and just simply chooses not to.
Yeah, I think that's a good
so really,
point. Asa.
attorneys are able to come in and make sure that there's a fair use of someone's income and not just what they tell the court it is.
I think it's a really good point, Asa, about this vocational expert. And this applies to divorce or modifications because the level of income is hugely important, whether it's child support, alimony, spousal support, maintenance, whatever your state calls it. You've got to set a level, and judges are willing, as you suggested, zero is not an option unless you have some disability issues, and that's another seminar we need to talk about is the kind of the shield and sword of saying some disability. But I think I've been doing this 27 years. About 25 years ago, I remember bringing a vocational expert into court, and the judges had never heard of it. I had used one in a civil case when I did some civil work, but they are so powerful. They can bring, certainty to judges. They have to have credible evidence and suggestions to set these levels of income. And, saying, look, I've interviewed in the workforce, I've talked to some employers, they would hire her today. For example, in your case, a nurse. We all know there's signing bonuses available for nurses. They need more nurses. So vocational rehabilitation expert is key. And I talk to my clients about it, as you just talked about. I don't think you can win a case without one, because you just can't come in and say, well, she can go to work. You need an independent third party, an expert to do it. And they're not that expensive, compared to a psychologist who's going to do a custody evaluation. So highly recommended. But let's transition to this cash job idea. I see it a lot, whether, there's all these companies, and I'm not going to name them, where you see these part-time jobs, whether they're selling lip gloss or makeup or tooth whitening toothpaste, or Tupperware, whatever it is, they're producing income. We had a case recently, and I'm curious your thoughts, Asa, where all of a sudden, you may think it's just a side job, it's a hobby, it produces a little bit of free cash flow, but when we found out, massive amounts, and I mean huge, like it's a full-time job money that's producing cash. And I think that's one of the dirty tricks is they don't disclose it. And you just think it's not worth digging because it's just a side job for fun, So what is your experience, Asa, with these cash jobs, whether it be that or a bartender or a hairdresser?
So we do see that a lot also. Certainly bartenders and hairdressers that have a lot of cash tips, you'll see a lot of undisclosed income. But there's a lot of things we can do. Now, if you're somebody who feels like you're going towards a divorce, it's not happening right now, but it's happening down the road, and your spouse has one of these types of jobs, my advice is to start keeping track. If you keep a digest, a diary running, say on this day, she indicated she made this amount of money, and keep that going, that's evidence. It's not definitive on the issue, there's credibility issues, but it's one piece of the puzzle. But there's a lot of other things we can look at as well. If somebody claims they don't have any income, or they're getting by off this minimum wage that they get from a waitress position, but then we look at their expenses, and their expenses show that they're paying a certain amount every month, yet they only have this amount of income and there's no debt to show for it, then the court is going to once again impute income to them to say, obviously, this money's coming from somewhere. You're not disclosing this money. And, courts are not dumb. They know about tips. They know that it's a large percentage of somebody's income. So even without some of those things, what we see is the courts regularly increasing somebody's income by 20%, 30% to account for those undisclosed tips. So it's not the end of the world. If your spouse is underreporting their income, talk to your attorney, and there's a lot of avenues that we can take to make sure it's a fair representation and not just what they say it's going to be.
Yeah, I think it is one of those tricks that you really, and I talk about exposing, and I think it's a strategic decision. I've talked a lot about this in the 10 Stupidest Mistakes, where we talking about Texas Hold'em, a game of poker. I am not a fan of disclosing what we've discovered. So let's just say she's already filed a financial statement that doesn't disclose this cash business or the tips. I'd probably hold it. I'd gather the information, show that I can prove that it's there. Don't bring it up. That way I can go after them with regards to credibility when it's too late for them to rehabilitate at trial. So just something to think about. I don't like to show my hand, but I think this is a huge opportunity. For example, even inventory. You have these spouses who are selling makeup or selling lip gloss or selling some sort of product. They buy a huge amount of inventory with marital funds. That's worth something. You got to find it. It's a dirty trick exposed, because what they want to do is stock up so they can make more money. They just use your money to support their income later on. So thanks, Asa. That's a huge one to really think about. So talk to your attorney about that. Melinda, I know we want to hurry through because we've got some questions. So let's get to you, Melinda. And really we want to talk about household expenses. One of the things coming out of domestic violence orders, for example, is marital expenses. I've talked a lot about it, about moving out, whether you get an order of protection. Is that something that really spouses use as a trick to kind of get off the hook for contributing to marital expenses, is a temporary restraining order?
Sure. So most courts issue what is a mutual standard restraining order from the outset of the filing of the initial complaint for divorce or petition. Depending on which state you're in, it's called something different. And these mutual restraining orders that are standard have some very specific language in there that prohibit either spouse from taking on a certain action, such as increasing credit card debts of the other spouse, or if it's a joint card, utilizing that card, taking money out from a line of credit, as well as not canceling insurance premiums, reducing policies. So those are just some of the aspects of a mutual restraining order. If your court doesn't have a standard mutual restraining order, there is an option that you could file for what I would call an ex parte restraining order. And this does not require sworn testimony in a courtroom. It's done on affidavit at the time of filing, where you're asking the court to issue specific orders. And you're really just telling the court what you want, why you want it, and the harm that will be caused if the court doesn't issue one. So if you have a spouse who is running up credit card debt or an expense, right before the divorce or during even the preliminary stages of the divorce, you're going to want to make sure that you're asking the court for the appropriate relief. Because if you've got, $20,000 in credit card debt all of a sudden that you can't pay for, there's other impacts, your credit report, where's the money going, and which leads to a temporary order request as well. So in a temporary order request, what you're asking the court to do is to allocate who pays what while the case is going on. So this could be a credit card bill, this could be the mortgage payment, and other orders as well that deal with children and spousal support or spousal maintenance and child support. So it's really imperative to make sure that you get the appropriate motions filed early on if the court doesn't issue some of these standard restraining orders that we see here in Ohio.
Yeah, it's a huge thing, just racking up credit card debt. I mean, I've met with guys that say, what do I do? And she's gone a spending spree. How do I stop it? And I guess in terms of these temporary orders, that's really the way to do it. But you also, what's more important is to ensure that they equally contribute to the marital household expenses, because I think one of the tricks I've seen is, especially when guys choose to move out, it's one of the things they don't think about is I call it double household expenses. They're going to pay nothing. I know you talked about including those in orders, but I guess you can also restrict what they can use their credit card for, or produce receipts to verify that it's a valid expense for the household.
Sure. So a lot of times what we see is the court issuing more of a blanket order, and you don't have the specifics in there. So if it's historically been used where, spouse A uses the credit card for what we would consider ordinary necessary expenses, then the court may say, okay, but it should stay consistent with the standard of living that incurred while you guys were together and before the divorce action was filed. So what you have happen is an increased amount of spending or spending that's not appropriate. One of the issues that I see a lot is a spouse will take a credit card to the grocery store and either do a debit transaction and just take cash out, or purchase gift cards and use those gift cards in the future, but said, well, this was the grocery store. I was buying groceries for the kids and myself, or other household, goods and furnishings that are needed, cleaning supplies. Whereas they're actually, padding their pocket, if you will, by taking the extra $100 cash through a debit plus bought groceries. Another dirty trick that I've seen is, all of a sudden hair salon bills or manicures and pedicures that were normally, let's call it $180 every 6 weeks, are now $350. They're getting gift certificates issued to them from their provider, which is increasing that cost, even though it looks like it would be normal in the normal course of spending and a normal expenditure. But they're actually, just being tricky and taking out cash certificates, gift cards, or something of that nature. So you can always ask the court to kind of beef up the order, if you will, and require that receipts be provided if it's just not a specific amount that the court is allowing the spouse to have on a monthly basis via cash.
Yeah, and I think it really just goes to show is to be proactive in the beginning, to make sure you're getting your attorney to ask for some limitations, as you talked about, some delineation of the expenses, rules of the road. A lot of counties have kind of these standing orders of what can be done, but I think you really need to be specific, because these tricks, as you suggest, they're just sleight of hand things that you wouldn't otherwise be thinking about, that can really get out of hand, especially when you're talking about, as you suggest, pedicures and running up what would generally be looked at as a standard of living. They get to trial and they say, well, yeah, now I'm $200 a week. Look at what I've spent, and this is my standard. But you've got to be able to show previous. Look, this is just increased debt, and you want to stop it, obviously, before it gets there. So that's good stuff, Melinda. Thanks for highlighting kind of another dirty trick in terms of racking up debt and failing to contribute. So appreciate it.
Yeah,
So,
and there's some other preventative measures that, our clients can use as well, which includes like closing out credit cards and open lines of credit that aren't being used. Reducing the maximum allowable limit on a credit card is a good one. So you're not closing out the account, cutting your spouse off in entirety, but you're reducing the amount of money that she could actually put on that card, which will save you in the long run as well.
yeah, good stuff. We want to get to the lightning round. I know we have a lot of questions out there, so you can continue to submit those via the Q&A and the chat section as well. We want to be able to address as many questions as we can live right now. Otherwise, you can submit them via email at coronavirus.divorce@cordelllaw.com. So let's get to some. We have about 15 minutes, and we should be able to get through most of these. We'll just toss these out to our panel and see if we can get some answers. Let me start with you, Misty, because this comes from Texas. It's Henry in Texas. I'm getting email from my spouse that I'm a substance abuser, etc. You get the gist. Should he or Henry deny and reply to all those emails, or what really kind of is the best course of action in terms of, obviously we want to get a lawyer involved to talk about it, but what do you think, and get him some initial thoughts?
Initially I would say don't ignore it, because it may look like you're acknowledging it, but I wouldn't engage in a whole lot of back and forth. I would maybe respond and say, this is not the case, and we're not going to discuss it anymore. A few things that I believe it was Jason mentioned about getting ahead of it. It may have been Asa, I apologize, but getting ahead of it with the SoberLink. We have SoberLink here in Houston, in Texas. We also have in this area the ability to do alcohol assessments. So if somebody is making an allegation that, hey, you're a drug addict or you're an alcoholic, there are things that you can do prior to the filing of the petition to kind of head that off. Get a drug test. If you can come back with a negative drug test, then the first thing you do when you show up in court and say, look, I was drug tested on this date. This drug test went back 30 days or 60 days. There was no drugs in my system. Hey, I've got an alcohol assessment. Alcohol assessment has come back and said, no, there's no concerns with alcoholism or alcohol abuse. These are things that you can do to protect yourself before the petition is actually filed. But I would say with regard specifically to the emails, it's okay to respond as long as you don't get into a back and forth about specific allegations, because again, you don't want to ignore it and give the perception that you're acknowledging what's being said.
Right. No, I think definitely responding in some fashion and something, and you have to be careful in terms of what you do say, because if you are using drugs in any way, whether it's recreational or otherwise, you don't want an outright denial and then a positive test, and now you've got a credibility issue. And likewise, you don't want to say, well, I just smoked one, but I'm good. Or, I only had a 6-pack today, but I'll be right over to get the kids, but otherwise I'm good. So I think it's really a measured response, as you suggest. Even getting a drug test is helpful, but I think you do respond. But go see a lawyer, get some really solid advice with more of the facts, so someone like that can advise you appropriately. So let me go to Melinda. Melinda, Emmanuel has a question. Can my kid's mother get a court order to keep my children away from my girlfriend, or make it where my girlfriend cannot be around my children?
So like you were just alluding to, some more facts would be helpful. But yes, that is possible, especially if it's during the pendency of the divorce proceedings and it's not a post-decree action. A lot of judges and magistrates don't like to see, immoral behavior occurring in front of the children while the divorce is going on, as well as putting the children in a situation that they may not be comfortable with, because this is new to them. So the court's really going to look at what's in the best interest of the children. So yes, I have seen many orders come across, and I've actually filed for some myself, to prohibit a spouse from having a paramour, girlfriend, boyfriend around the children if it's causing harm to the children.
Yeah, and I think it's generally, a good cause or strategy to just not have that girlfriend around. Avoid the whole notion of bringing attention to the fact that you have one. I know it's difficult to just say no. It's like social media. We didn't get a chance to talk about the social media dirty trick. I'm a big believer. I'll tell my clients every day, let's get off of social media right now. And likewise, let's not have a girlfriend. There's time for it when this is over. I know it's difficult. I know you want to have a relationship that you didn't have, and that's why you're getting out of one. But I think the last thing you need is a judge to be distracted by something that really doesn't matter. And so I think that, to me, as Melinda said, we need a little bit more facts to kind of make sure we could give you the best answer to that question. So seek an attorney and really talk about whether or not that's something you want to continue to pursue, especially in your custody.
And one other thing with that is that it could also impact any kind of support requests as well, especially if you're exposing your children to this other girlfriend. This girlfriend may be living in the same household. Does that increase your household income? So there's a lot more that goes to it than just a simple, does my girlfriend have to stay away?
Yeah, huge. That's why they're so complicated. Whether, a roommate, a parent, someone, anyone living with you, anyone contributing, it's just complicated. And when representing guys, you don't want distractions. So thanks, Melinda. Hey, Jason Bobby from California has a question. My wife asked me to get an expensive whole life insurance prior to separating from him. The life insurance protects her and my kids in case of death or disability, even after divorce. It costs Bobby a few $1,000s per month to maintain that. Can Bobby's alimony be adjusted taking this monthly insurance in mind? He was hoping it would be viewed like health insurance as a necessary protective measure. So really, just question becomes what can that be used for?
Yeah, so it's a pretty loaded question that has a lot of nuance to it. But Bobby, what I would say first and foremost is, if we're in the post-judgment status versus pre-judgment, that's going to be a big determination on if we're using a calculation or if we're using factors. So in California, for any type of spousal support obligation, if we're in a pre-judgment standpoint, we're really looking exclusively at income and tax deductible types of matters, and it's arrived at a calculation. If it's post-judgment, there's a number of factors, and one of those factors would be obligations that you're maintaining, assets that you have, things of that nature. Just from a practical standpoint, if we're talking about a whole life insurance policy, it might be that you could replace the whole life policy with a term policy. And generally speaking, a term policy is going to be a significantly less expense and still provides the same level of security that might be court ordered. So I would certainly look at your decree if it's post-judgment and determine, okay, does the judgment say that I have to maintain this specific policy? And that might be the case because it has some sort of cash value or something like that. But if it doesn't, if it just says that you, Bobby, are required to maintain insurance, I would speak with your insurance agent first and foremost and see if you can replace that whole life policy with a term policy, which may, kind of cure the issue in and of itself. But as to modifying the obligation, generally speaking, if the existing obligation was put in place with those underlying facts that you had these expenses, generally you're going to have to show some sort of change in circumstance. So if you've had any kind of offsetting reduction in income, or that your former spouse has had some sort of increase in income, certainly those could be factors to modify. So those would be the sorts of things that I would look at first and foremost. And then certainly because this is, because spousal support specifically is one of the more nuanced types of issues in California specifically, I would say, it probably would make a lot of sense to schedule a consultation where we can look at the fact pattern a little more specifically to your case.
Yeah, I think you need to look at the judgment. It's not unusual, in my experience, to have opposing counsel ask for a insurance policy to kind of guarantee or back up the maintenance plan. I think you want to look at that. You want to look at the language if this is post-decree to see whether or not that was a consideration, whether or not the maintenance was reduced in consideration of keeping this whole life. There's just a lot of questions. Certainly, it's worthy of spending an hour with an attorney, as Jason suggests. So, Asa, got a question from Earl. So, how do we mitigate or reduce the potential of not seeing our children in a state like California or New York that's a high COVID state? Earl particularly hasn't seen his kids in 10 months. And there's a secondary question here with that that's unrelated. What happens if the male is the victim of female violence? And I can answer that one too. I've got an example of that. So, two-part question for you.
Sure. Well, we'll deal with the first one first. As far as trying to avoid any lapse in your parental access, being allowed to see your kids, I would do everything you can to make sure you're complying with your state's requirements, staying safe in that regard. But if that's not working and your ex is not allowing you access, you've got to talk to an attorney right away and get in front of a court right away. The example that Misty gave about just having a petition filed and not getting into a court for so long is really difficult. Of course, we do see those, but there's also times when we can get in front of a court on an emergency basis and get there right away and address these issues. Now, the longer you go without seeing your children, the harder it's going to be. So, my advice would be to talk to an attorney about getting in front of a judge, filing your petition, and trying to get your parental access going again. COVID shouldn't interfere with seeing your children. In New York, as I know in most states, they enacted specific legislation and governor's orders directing that custody orders not be interfered with simply because of COVID. There has to be something more. And if somebody's interfering, you got to take steps to correct that. Now, with regard to your second question about a husband who's being abused, I've had those cases, and they're tough. But courts take domestic violence seriously. What I would say is document what's going on. Don't be embarrassed about it. Talk to an attorney, and depending on the severity of what's going on, you put a plan in place to protect yourself and to bring it in front of a court. It is more prevalent than people know. Husbands being physically or verbally abused by their spouse. And there are things that we can do to help protect you. So you really need to go talk to an attorney to learn all of your options, because I have 100% brought a battered husband in front of a judge requesting a stay away order of protection and been successful in getting it.
Yeah.
This isn't this is absolutely gender neutral, and you should really put everything aside to make sure that you're safe and do what you have to do to protect yourself. The first thing to do is to talk to an attorney, like I said, learn all your options and help make a decision about the best way to move that forward.
Yeah, you're right. Asa, I've got an example of that, and I've always talked about unapologetically stepping on toes, and this is a classic example. I had a client who was assaulted by his spouse. She hit him with a cast iron skillet, broke both orbital sockets. We go for an order protection. We get the next parte. We go for the full order, and the judge looks at me and says, "Look, well, he could have just fought back or run away." And I was just appalled, and I said, "Judge, if I represented the man who was the person who assaulted, you wouldn't be asking those questions." I said, "Justice is supposed to be blind. So why don't you just not look at the male-female here and just make a decision based upon the facts?" And the judge kind of reeled back and realized that it really should be, as you suggest, gender neutral. The facts are the facts. It doesn't matter, what role they play, whether it's, female, female, male, female, male, male. It doesn't matter. This guy was assaulted, period. And so I think you have to find a lawyer who will unapologetically step on toes, maybe ruffle some feathers in court, and really draw attention to the unconscious bias that's going on in our court system. It really is the typical gender bias. We look at it. So we live in that world in the family court system, and we just have to fight it. So let me go to Melinda, as we have about a few minutes left. Mike has a question, Melinda, regarding income, and this is post-judgment. Mike's ex gets a lot of money from her parents. She's imputed, apparently in the judgment, a modest income of just about $21,000. She chooses not to work, it appears. What can Mike do to convince the courts to impute more income?
So, depending if it's spousal support or child support, I would still argue that income is from all sources, regardless of which support order it should be for. So if he knows she's getting that income and she's living a lifestyle that doesn't support the 20,000 plus whatever support he is giving her, we need to document it. We can do that by bank statements. We can do it by requesting certain documents from her credit card companies, or if she's driving a Mercedes or a Maserati, who's paying the card note, where is all that coming from? So going back, I don't remember which one of the panelists earlier was discussing it, discovery. Discovery is an important tool, and it should be used in every situation and not just be the forgotten avenue of getting that information that's needed to appropriately litigate your case. So if it's there, we should be able to find it. Yeah. A lot of times you also have cash that's coming from parents to the individual, but if you're actually looking at the spending, receipts or whatever, you're going to be able to find it and trace it. And there's some really good forensic accountants that can also assist us in tracking down where money's coming from and how much is actually being spent.
Yep. Hey, let's go to Misty. Let's give you a question here from Yanni. 30 seconds, because I'm going to get through as many as we can in the final couple of minutes here. Misty, in 30 seconds, here's Yanni's question. His ex is denying court order visitation. Yanni doesn't know what to do. One of the allegations the ex is making is that Yanni's father inappropriately kissed the 5-year-old daughter on the lips, but she's never filed anything with the officials, with the police, with the court system. She's just simply saying, child's not safe, therefore you don't get to see the child. What should Yanni be doing right now?
Yanni should be speaking to an attorney right now. That is going to be the quickest solution. Speak to an attorney. If you have a court order in place, you can enforce that court order. You have means of enforcing the terms that are written. So if they're denying you access, we can file a motion for enforcement against her, and the burden will be on her to prove that the child is unsafe or in an unsafe environment, and she has justification for denying visits, which typically is not the case.
Great. Debbie has a question. I'm going to go to Jason real quickly. Debbie says, my son's wife kicked him out. Does he have to pay mortgage household prior to the divorce? Will they need to sell the house, and can she delay the sale? Give me 30 seconds.
I'm going to give you a very attorney response and say it depends. Certainly your son, if he's on the mortgage note and he wants to preserve his credit, you have to kind of make this cost benefits analysis of, if I don't pay my mortgage payment, it's going to affect my credit. am I going to be able to secure a new loan 6 months from now when I'm trying to buy a new house? If the answer to that question is no, then I think you need to make the mortgage payment, and then certainly file a case, seek reimbursement. A lot of these types of expenditures post-separation or post-filing are reimbursable. And then certainly once we can sort out the financials, we can likely get a judge to order some sort of expense sharing once we know what the total situation would be between both parties.
Great. Asa, Kelly says, are informal agreements made during the initial stages of separation valid in any way?
Well, it depends on how it's made. They can be valid if they're prepared properly, executed properly, and then can in some ways be enforceable. But generally speaking, if they're not prepared by an attorney, they're not going to be enough to be a basis for a divorce. Certainly with regard to issues like custody and support, there's a lot of specifics that have to go into that agreement for it to be binding on the parties. So it would really depend on how they did it and what they're addressing to know whether or not it's going to be binding on them long term.
Great. Let me get to maybe one more question, Melinda. Andy says, I'm currently in the process of a divorce. I don't have a parenting plan or any type of custody agreement. I have a young daughter who would like to come with me on a private visit with my family in another state. My ex always finds a way as an excuse, COVID being the current one, saying I can't take her with me. Is there any legal thing she can do to prevent me from taking my daughter on a week trip to see her grandparents without my ex, who live in another state?
So without any current orders in place for parenting time, I would say that, in my states that you have equal but competing interests. So no, there's nothing prohibiting you from taking her if there's not a court order that says you're not allowed to remove the child from the state. Some of those mutual restraining orders that I spoke of earlier are not to permanently remove the child. It doesn't mean that you can't take a vacation somewhere.
Got it.
Or a short trip.
Yep, great. Sorry, we're making these quick. I just wanted to get through one more. I know we're over time, but I'm going to do one more question. Misty, Garrett has a question. Garrett lives in New Mexico, lived in Washington State, but child support the case is from Pennsylvania. Washington is currently in charge of the case, and I'm being told that Pennsylvania could say they don't want the case transferred back. I currently have one of the kids whom I'm paying child support for living with me. She's been with me since August 1. I'm currently still paying mom child support while we get custody settled. So I guess that's a lot of questions about jurisdiction. The UCCJEA comes into play, which is the Uniform Child Custody Jurisdiction Act. We're talking about which state has jurisdiction over child support orders. It doesn't look like they have a divorce order yet, Misty, because it says that currently still paying while they get custody settled. So the question, there's a child support order at least in Pennsylvania, but they now live in New Mexico or Washington State. So what do you think? It's a tough one.
I think it depends. Yeah, I think it depends on how long they have been in which particular jurisdiction. I know specifically in Texas and a lot of places, the court doesn't obtain jurisdiction of the case unless you've lived there for at least 6 months in a particular county for 90 days. I think I heard something about they've only been there since August. So my first instinct would be that you probably haven't been there long enough in order to transfer the case to New Mexico where you're residing, which means that the state that's currently facilitating the child support obligation at this time is probably still the primary state. There's a lot of questions. Where is the mother? That's one thing that I didn't hear. Is there more than one child? Is there one child with dad? Is there one child with mom? With so many complicated jurisdictional issues and so many states involved, again, I think it's best that you sit down with an attorney, give some additional information, some additional facts so that we can help you figure that out.
Yeah, I think it's important because time is not on your side. There are jurisdictional issues out there. Fortunately for this question, we have offices in both New Mexico and Pennsylvania. There may be one state more advantageous over the other in regards to custody or child support or even divorce or maintenance and alimony. So many questions in play there. We need to know some more facts. But again, time is not to your advantage because there is specific jurisdictional timelines that you need to meet in order to secure the right jurisdiction. Depends on where mom is. We know we have a decretal state for child support. Question is, do we want to keep it there or not? I encourage you to schedule a consultation. Especially with us, we can have both attorneys from Pennsylvania and New Mexico on the line. We could give you the best advice. Reach us at 866-DADS-LAW. So that's all the time we have for today. We spilled over a little bit trying to get to as many questions as we can. We'll take the rest of the questions. I'll put those in the podcast that we'll have next week, and we'll answer those for you. So tune into that podcast next week where we'll just take the questions that we have left over from this town hall. Find us on the web at CordellCordell.com. Again, 866 Dad's Law. Love to chat more, get some more details, give you some good legal advice with regards to your situation. We'll see you next month in October, where we'll bring you another town hall, and we'll talk to you next week during the podcast. Until next time, have a good week.